Good morning. This is the time and place for zoning cases hearing for December 14, 2016. My name is Bradley Collin. I will be conducting the hearing as a hearing officer today. We have 2 cases scheduled, and the relevant exhibits are posted on the panels located directly behind me. If you wish to speak, please write your name and address on one of the green speaker forms, which have been provided by the front door and submitted to our planning assistant. I would like to inform everyone that the official proceedings of the planning hearing officer's hearing are recorded as part of the public record. Notification of this hearing was accomplished by the use of public notices, which have been mailed to property owners and tenants located within 500 feet of the subject property, physically posted on the site in question, placed in a local newspaper. The hearing will proceed as follows. I will read the description of the application or request. The case planner will make a brief overview of the case, give analysis, and make a recommendation. The applicant will then be asked to come forward stating both name and address, and will be asked to present a case within a 15-minute time limit. Others in support or in opposition of the application and interested parties will be asked to come forward and speak, again clearly stating both name and address for the record, within a 3-minute time limit. And lastly, if the applicant will be given the opportunity, if they decide, to make closing comments in response to testimonies given by preceding speakers with a 5-minute time limit. The hearing will then be closed, and the case will either be taken under submission or a decision may be made. We have 2 cases scheduled for today. Both are conditional use permits. The first one's located at 1725 South Brand Boulevard. Case number PCUP 1624859 for a new massage establishment use. Second case is located at 1302 South Brand Boulevard. Case number PCUP 1622327, and this is for a tavern use. Under the provisions of Title 30, Chapter 30.42 of the Glendale Municipal Code, a conditional use permit shall be granted if the 4 required findings are present. If the evidence presented in the application at the hearing meets the required findings, then the hearing officer can either approve, impose conditions for approval on the case in question. If the findings of facts are not evident, then the case will be denied. At this time, I would like to call on our case planner for the first case, Ms. Toledo.
Thank you, Mr. Collin. As stated, this project is located at 1725 South Brand Boulevard. The business name is Oak Massage. Today, the applicant is requesting a conditional use permit to allow the operation of a new massage establishment in the C3 commercial service zone. And this is subject to the standards listed in Chapter 5.64. The proposed massage establishment is approximately 1,800 square feet. It's a vacant commercial tenant space. It is located on the west side of South Brand Boulevard, and this is just north of San Fernando Road, which is basically the gateway entry into Glendale from the city of Los Angeles. Currently, there are no on-site parking spaces, but as you can see in the staff report, this is a change of use, and I'll highlight that in my presentation. Because it's under 2,000 square feet, we do have some regulations for these types of uses where they don't need to provide additional parking if they're under 2,000 square feet. And that is the case here as well. Staff is recommending approval today. All 4 findings can be made in a positive manner. I'll briefly highlight those. Just a brief overview as it relates to the surrounding zoning. As stated, this subject property is Zone C3 in the commercial service, surrounded also by C3, with the exception to the north, they have a commercial auto zone. Primarily, the majority of all Brand Boulevard is as we know, the Boulevard of Cars, and it is Zone CA, but this particular area along South Brand Boulevard is where the transition is to the C3 commercial zones. The closest residential would be most likely behind the Seeley's building, which is somewhat diagonally to the southeast of the subject property, so I don't anticipate any issues there where it would be detrimental to any residential uses in the area, because it's a bit of a, not far, but not next door, basically is what I'm saying. The other thing I'd like to highlight, that this particular location does have a public school and a public park across the street. However, Brand Boulevard, as you know, is a wide major arterial with a landscaped median in the middle. The approximate width of Brand Boulevard is 130 feet wide with that landscape median. So staff doesn't believe that there would be any issues with the fact that there are these public uses directly across the street. In addition, those public uses do not have their main entrance. For example, the school is accessed from Cerritos Avenue, and the park is accessed from South Brand, but closer to San Fernando Road. So, and the play structures, I recall, are further east, so not directly adjacent to Brand Boulevard. So, having said that, staff does not believe that those public uses will be an issue with this particular use proposed across the street. We didn't receive major concerns from other departments or divisions. Staff is proposing, recommending certain conditions that include conditions forwarded by the police department and the city attorney's office are included as well to mitigate any potential negative impacts this new use may have. We will be seeing more of these types of requests or entitlement requests for conditional use permit for massage establishments because, as you know, there have been some changes in the law where now massage establishments are at a local jurisdiction being reviewed through the conditional use permitting process. Again, to mitigate any potential impacts that can occur as a result of this particular use. So I will briefly just highlight some of the findings that are in your staff report. I won't go into depth regarding my analysis. I've highlighted major points that I think are important. In terms of the general plan, finding A, again, the proposed use will be consistent with these various elements and objectives of the general plan, and no other elements aside from the land use element should be impacted. So again, the open space, recreation, housing element, again, all of them, no issues there. In terms of the use and its associated structures and facilities will not be detrimental to the public health or safety of the general welfare and the environment. I've outlined earlier and in the staff report and my presentation in the offset how this particular use would not impact public facilities and its location related to the proximity to the nearest residential uses, so no issues there. The use in facilities will not adversely affect or conflict with adjacent uses or impede the normal development surrounding the property. Again, just to reiterate, no issues there. Their proposed massage establishment will not adversely affect or conflict with the adjacent uses. We have we have retail to the south, another mix of commercial in this particular strip of abutting the subject site. We have also vehicle repair garage to the north, and we also, I already stated what the public uses or facilities are across the street. Lastly, adequate public and private facilities such as parking spaces and traffic circulation measures are provided for the site. They are in place because this is an existing use. So this is an existing development, so we don't have to recreate, if you will, new utilities. And again, regarding the parking, we know there is no on-site parking. However, the proposed change of use, 1,800 square feet, it's less than 2,000. For the previous use, which was a retail bakery, to a massage establishment, which is a personal service type use, will not require additional parking per the zoning regulations under 3032.030. Just a couple of conditions I wanted to highlight that are in your staff report. Number 11, which refers to the operating hours of the massage establishment, which shall only be between the hours of 10 a.m. to 10 p.m. each day of the week. And the applicant and I have had a dialogue prior to this presentation, so when he's up at the podium, he can address whether or not he agrees with that condition. I believe he does, but he can inform you as well. And lastly, condition number 13, that the granting of this permit would be for 3 years. That's staff recommendation to have it for, again, 3 years as opposed to 5 or longer. If you have any questions, that would conclude my presentation, but I am available.
Thank you, Ms. Toledo. I actually do have a couple questions. The hours of operation, are these hours that the police department has proposed, or is it something that...
No, this is, I don't believe that the police department had specific requirements or conditions stipulated for the hours of operation. I'd have to defer to the comments that they submitted, which I believe you have a copy of. However, these hours are based on what the applicant has informed me, how he operates his business. He currently, I believe, has, my understanding, another massage establishment. I don't know if it's under the same name, but in the city of Glendale, that currently operates, and it's been operating for a few years, and I believe more or less the hours are from 10 to 10, but I would have to defer to the applicant to confirm that. But this is his request.
Okay. And then the second question is, can you briefly go through the thinking on the expiration?
Yeah, of course.
3 years.
The reasoning behind it is this is a new massage establishment. Most of these that you're going to be reviewing and other hearing officers are pretty much the first of many massage or CUPs for massage. So in this particular case, it's not a continuation of an existing where if it were existing, they've already sort of, quote unquote, proven themselves, if you will, whether or not they would have an impact to the surrounding. We don't know yet with this particular use. I'm not saying they will, or I'm anticipating it. However, just to err on the side of caution, 3 years would give them the opportunity to prove themselves, to show that this particular use at this location will not be a detrimental impact on those surrounding uses. Whereas if we knew in advance, having been established, then we'd know more, but at this point we don't. And then that was the reasoning behind it, just again, give them an opportunity to be able to prove themselves. And then when they come forward in the future in 3 years, then maybe at that time they can make their request to extend from a 3 year to 5 or whatnot.
Okay, very good. Thank you.
Thank you.
At this time, I'm going to open the public hearing. I have, unless I get any others, I have one speaker card. Is there anybody else in the audience that would like to speak on this case? Okay, I have a speaker card from Mr. Kasim. Am I pronouncing that right?
Exactly right. Thank you.
Please state your name and address for the record.
My name is Amir Qasim, 1159 West 3rd Street, Unit number 6, San Pedro, California, 90731. The only thing I was, after I hear what Ms. Malika, she present the case very well, the only thing I want to mention that's this is actually an expansion of for a second location. The first location located in 1117 South Glendale Avenue. The name of the business is Oak Massage. It's been operated for Oak Massage been like in business for over 5 years. Has proven a good neighbor, as there is no report of complaint or other business from other business or resident. For the hour of operation, we are this business to operate it. Oak Massage operated from 10 a.m. to 10 p.m. and that's where we request the hour of operation to be. We're okay. That's it. That's the only thing I want to add. It. We believe that all the finding will be met as.
Can you please go through those findings?
Sure. Okay. For the proposed use will be consistent with various elements and objectives of the general plan. The subject site located in the C3 commercial zone. General plan and use element designated its community service. The massage establishment will be consistent with the element of objective of the general plan. The land of use destination designation of the site community service where retail service along the major street. The project site is already developed, and the applicant request is to allow tenant improvement of an existing commercial space to a massage establishment. The existing commercial space is surrounded by other complementary business, including retail service, commercial mix of use. This application does not include any added floor area or modify of the existing building threshold. There will be no increase in the required of parking for the use. For the finding fact B, the massage establishment will not be detrimental to the public health, safety, or general welfare, or the environmental. In fact, the service they offer will be intended to improve it. This as I said, this application will be for the second location. The first location is Oak Massage, located in 1117 Glendale Avenue. For the use of facility will not be adversely or conflict with adjacent use or impede the normal development of the surrounding property. A massage establishment will not be impeded the normal development of the surrounding area, since the property is already fully developed in the immediate vicinity of the subject site. This property with various of commercial use, including retail, restaurant, community service, etc. This application is to allow tenant approval for existing commercial space. The massage establishment will not be adversely impact nearby use on this commercial street. And finally, for the D. Okay, the new massage place will not result in the inadequate public or private facility. The project site is already developed and the space is being operated as commercial service. The property it's legal non-conforming in terms of parking and landscaping. South Brand is fully major arterial and can handle the existing traffic circulation adjacent to the site. Thank you.
Okay. Question for you.
Sure.
The conditions of approval that have been outlined and included as part of the staff report, are you in agreement with all of those conditions of approval?
Yes.
Okay. All right. Thank you very much.
Thank you. Sure.
I have no other speaker cards for this case. Again, just to verify there's no one else in the audience that would like to speak on this project. I'm going to go ahead and close the public hearing. Based on the findings recommended by staff, the facts and information presented at the hearing, and other applicable department input, I'm going to approve the subject conditional use permit, case number PCUP 1624859, subject to the conditions listed within the staff report. After the hearing, the decision will be prepared in writing, will be in the form of a letter sent to the applicant and to all persons who responded to the public notice, either by speaking at this hearing or by submitting written responses and have provided their name and mailing address. The date of the decision will be the date appearing on the letter. as it relates to appeals under the appeal provisions of Title 30, Chapter 30.62 of the Glendale Municipal Code. The decision may be appealed to the Planning Commission within 15 days of the date of the decision. Anyone wishing to appeal may obtain forms and brochures from the Permit Service Center located on this floor, room 101. And thank you very much. The next case we have on the agenda is located at 1302 South Brand Boulevard, conditional use permit case number PCUP 1622327. Ms. Saad, may I have a staff report, please?
Thank you, Mr. Collin. As stated, this is a conditional use permit for PCUP 1622327 for a tavern with on-site sales, service, and consumption, and off-site sales of alcoholic beverages. The proposed tavern is located at 1302 South Brand Boulevard. The business name is Pacific Plate Brewing Company Tap Room, and the applicant and owner, Stephen Kushian, is present here this morning. To provide site context, 1302 South Brand is in the commercial services area of the general plan and the zoning district commercial auto. The lot, which houses 1302 South Brand, is approximately 4,600 square feet and is developed with a two-story mixed-use building with 6 residential units on the second floor. There are 2 commercial units on the ground floor totaling 3,800 square feet. Presently, the building has 1 tenant on the ground floor called 1300 Bar, which is a tavern. The subject tenant space is approximately 1,030 square feet. The subject site is surrounded by commercial auto zoning and has auto dealership uses to the south, east, and west, and the previously noted tavern to the north. Further east, Cypress becomes residential, though not directly abutting the subject location. The project is exempt from CEQA review as a Class 1 existing facility. The proposed tavern is consistent with elements and objectives of the general plan. The proposed tavern is located in an area which is intended to accommodate the maintenance and expansion of vehicle dealers while still providing for alternate complementary commercial uses. The district is designed to be an attractive, pedestrian-friendly urban auto row with a mix of commercial uses to ensure the future vitality of uses within the district. Taverns are a conditionally permitted use within the commercial auto zone and therefore consistent with the land use designations. The applicant's request to operate a tavern would be in keeping with the goals of the area to promote business and pedestrian-friendly commercial uses. The subject site is along South Brand Boulevard, identified as a major arterial in the circulation element, and just south of East Cypress Street, identified as a local street in the circulation element that is suitable for this type of use. The operation shall be required to comply with the city's noise ordinance and as such will be consistent with the noise element. Given that the project site is already developed, other elements of the general plan, including open space, recreation, and housing elements will not be impacted as a result of the tavern. The applicant's proposal for a tavern is to operate a tasting room that will only offer Pacific Plate craft beer. Their pending Type 23 license with the State Department of Alcoholic Beverage Control classifies this establishment as a small beer manufacturer. Type 23 licenses allow manufacturers to sell at 6 additional retail locations. As this license is tied to Pacific Plate's brewery in Monrovia, California, which is where the actual brewing will be taking place, it is of note that the company has operated as a brewery and tap room for 3 years and has had 0 alcohol-related incidents. They maintain a perfect record with the California ABC and Monrovia Police Department. The suggested limit for this census tract, which is 3025.05, is 3 on-sale and 2 off-sale establishments. There are currently 5 on-sale and 5 off-sale licenses in this tract. According to the police department, there was 126 crimes in the census tract in 2015, which is 29% below the citywide average of 178. There are a few public institutions such as schools, churches, a park, a fire station, and a hospital located in the general vicinity of the tavern. However, these public institutions are not anticipated to conflict with the applicant's request for a tavern, nor is operation of the tavern anticipated to be detrimental to the safety and public welfare of the neighborhood. It should be noted that the existing tavern next door has not proved to be detrimental to the neighborhood. The building was originally developed as a mixed-use project, and a tavern has been present at this location since 1962. A noted difference between the present 1300 bar and the proposed Pacific Plate tap room is that 1300 bar has a full liquor license, and Pacific Plate will only be serving their own brand of craft beer. Adequate public and private facilities, such as utilities, landscaping, and traffic circulation, are provided for the site and the proposed use. While there are no on-site parking spaces, the proposed change from an approximately 1,030 square foot fast food use to a tavern will not require additional parking per zoning regulations, as the subject space is less than 2,000 square feet. Further, the project does not involve a floor area expansion. There are on-street parking spaces along Brand Boulevard, even though these spaces are not considered required on-site parking. Hours of operation are proposed from 12 p.m. to 12 a.m. Monday through Sunday. In accordance with plans submitted as part of the application, there are a total of 50 seats available to patrons at the tavern. The conditional use permit was routed through various city divisions and departments, and no major concerns were received. Suggested conditions made by the police department are included in the draft conditions of approval. The applicant is not expected to negatively impact the neighborhood, and the suggested conditions to the CUP would serve to mitigate any potential negative impacts. Staff believes that all four findings for the conditional use permit can be made in a positive manner, and therefore recommends approval with conditions. This concludes my presentation. I am available to answer any questions the planning hearing officer may have.
Thank you, Ms. Sud. I do have a couple of questions. And maybe clarifications. Have we received any responses from the neighbors upstairs?
There have been no
Or
comments
email
received.
questions, nothing
Nothing.
about the project? Okay. And then the existing tavern that's next door, is that going to remain, or is this an expansion, or is this...
The 1300 bar is a separate entity and will be remaining.
Okay.
There are two commercial spaces on the ground floor.
There'll be two separate businesses?
Yes.
Okay. And then my last question, in terms of loading, do we know when and where that will be taking place?
The applicant has stated that deliveries will occur on Mondays between noon and 4. And because of the nature of the deliveries taking place, they wouldn't require a large loading space and can park on any of the spaces on Brand Boulevard.
So it'd be a vehicle that would fit into the normal size spaces that are there. It's not going to be a major
Correct.
truck coming through. Okay. Thank you very much.
Thank you.
This time I'd like to open the public hearing. I have one speaker card. Again, is there anyone else in the audience that would like to speak on this particular project? Okay, seeing none. I'd like to ask Mr. Stephen Kushian, please, to come forward. Again, please state your name and address for the record.
Good morning. My name is Stephen Kushian. My home address, 816 West Colorado Boulevard, Apartment B in Monrovia, California. The project address is 1302 South Brand Boulevard, and the name of the business is Pacific Plate Brewery Taproom. Good morning, Mr. Collin, members of the city, members of the community. I'm one of three founders of Pacific Plate Brewing Company in Monrovia, California. The Pacific Plate Brewery Tap Room is a proposed expansion of the Pacific Plate Brewing Company. The company was established in 2012 and opened its doors to the public in August 2013. It specializes in brewing unique craft beers with Latin American ingredients and flavors, as well as more traditional European styles. Craft beer has emerged as one of the fastest growing markets in the United States. From 2008 to 2016, the number of craft breweries in the United States has grown from around 1,500 to almost 5,000. Craft beer relies on passionate individuals willing to invest in small-scale production with an artistic and innovative approach to beer. 700 square feet of the 1,600 square foot Monrovia location is dedicated to an on-site tasting room where patrons can purchase beer for on- and off-site consumption. For on-site consumption, patrons can choose from a selection of 5-ounce taster-size pours or opt for a 12-ounce or 16-ounce full pour. For off-site consumption, patrons can purchase 1-liter and 2-liter sized refillable glass bottles known as growlers. Growlers are filled directly from the draft beer taps, and repeat customers can refill their growlers with any beer on tap. The proposed Pacific Plate Brewing tap room in Glendale is classified as a tavern with respect to the conditional use permit. The proposed use as a tavern is consistent with the elements and objectives of the general plan. The location is part of an attractive, pedestrian-friendly auto row with a mix of commercial uses including shops, restaurants, and an existing tavern. The proposed use will not be detrimental to the public health or safety, the general welfare, or the environment. It will offer only Pacific Plate beer made in Monrovia for on- and off-site consumption. The proposed use will not adversely affect or conflict with adjacent uses or impede the normal development of surrounding property. The adjacent existing tavern has coexisted with its commercial, residential, and mixed-use neighbors for years without any detrimental impact. Additionally, the proposed conditions of the Community Development Department will ensure that the tap room does not adversely affect the neighboring uses and public facilities. Adequate public and private facilities such as utilities, landscaping, and parking will be provided for the proposed use. As the project site is already developed, no such additional facilities are required. Sufficient parking requirements were approved and met with the previous use as a coffee shop. The proposed use will not intensify or contribute to adverse impacts as a tavern. It will only retail Pacific Plate beer and not hard alcohol, wine, or any other alcoholic beverage made by any other producer. This proposed use is allowed by the California Department of Alcoholic Beverage Control as a duplicate license and privilege of the existing Type 23 small beer manufacturer license that is attached to the production brewery in Monrovia. The proposed use is classified by the California ABC as a satellite tasting room. It should be noted that in 3+ years of operation, the Monrovia location has had 0 alcohol-related incidents and maintains a perfect record with the Monrovia PD and the California ABC. The proposed taproom is located in a crime reporting district that is 29% below city average. The Glendale Police Department has contributed to the proposed conditions, and there was no evidence to suggest that the proposed taproom would encourage or intensify crime. The proposed taproom will limit its hours to 12 a.m. closing time. The owners and staff are trained in the LEED certification program from the California ABC. The program teaches ABC licensees responsible alcohol serving practices. The proposed taproom will not adversely affect any public or private use in the surrounding area, including, but not limited to, schools, churches, daycares, parks, or hospitals. It will abide by the proposed conditions that are intended to ensure compliance with all municipal codes and state laws. The proposed taproom will serve the community by providing access to fresh, local craft beer brewed with flavors and ingredients as diverse as Angelinos themselves. It will bring the culture of craft beer to the heart of Glendale and draw patrons from the surrounding communities and beyond. The Pacific Plate Brewery taproom will be a unique and vibrant destination in the city of Glendale. Thank you.
Thank you. I do have a couple questions
Sure.
for you. Is there any proposal to serve food at this location, or is it strictly just going to be beer?
The proposal to serve food would be based on outside food companies who have a catering license that abides by the health department regulations, who would actually come in and set up a temporary food vendor stall. That would be a separate business from ours, so they would have to get their appropriate permits from the city to have that type of catering style business on our premise, and they would have to comply with the health codes directly. This is a model that we use at our Monrovia location, where we actually bring in food trucks and outside caterers who come, I guess, with the complete package. They have all their licenses and permits and can just set up shop mobily and serve food.
So if these are food trucks, I assume then that they're going to be parking somewhere in the right-of-way?
If they are food trucks, they would have to park appropriately and, again, comply with any city provisions. And if they are outside caterers, they would actually set up inside of our location, which would be allowed by their health department permit.
I would think with the food trucks, most likely you would want your patrons consuming the food inside and not taking their beers out on the
That's correct.
sidewalk, and then you've got enforcement issues potentially.
Yeah, the ABC would prohibit anybody from taking alcoholic beverage off the property, so that's not allowed. We do have this instance at our Monrovia location where the food truck is parked outside and customers are simply requested to leave their beer inside when they order, and then they're welcome to bring their food inside and eat it. And a lot of food trucks will actually have their staff come inside the location and take orders and then fulfill the orders with table service so the customers never have to get up and leave.
So then they prepare the food in the food truck and then bring it into the restaurant.
That's correct,
or the
into our
tavern.
location.
Okay. And then is there any proposal for dancing going on inside
No.
the...
No, there's no dancing allowed.
So there's no dance floor, nothing like that being
No,
proposed?
none whatsoever.
Okay. And then there's an existing tavern next door. Is this a completely different operation than what you're proposing? Is it going to be similar? Or are there any conflicts
That's
between
correct.
the two?
The only similarity would be that they're classified both as taverns in the city of Glendale. The ABC doesn't use the designation tavern for our type of business. That's something completely different. Our type of business is a small beer manufacturer with a tasting room or tap room privilege. And so for the purposes of this hearing, we use the word tavern because that's how it's defined in the Glendale Code. But with the ABC, we're actually a beer manufacturer with a tasting room, and this would be considered a satellite tasting room. The similarities would be that we do serve beer for on-site consumption, but I think they end there. We don't serve any type of hard alcohol or wine, mixed drinks. We don't serve beer made by any other producer. And the intention is a lot more like a wine tasting room than it is like a bar or a tavern, where customers will come to actually taste and experience the product rather than drinking as a means to the end.
Do you have an actual menu that if patrons would come in and look at?
Yes, we have a rotating menu. Our Monrovia location has 8 beer taps, and this location will expand to 16 beer taps. At our production facility, in the last 3 years, we've made about 50 different beers, so we're always rotating different styles of beers. Some of our most popular beers are ones made with Latin American ingredients like our horchata stout, our mango IPA, our Oaxaca coffee stout, our Jamaica wheat beer. And so these are very unique offerings that are even challenging kind of the norms of craft beer today to infuse these local and cultural flavors into established styles of craft beer.
Okay, and then getting back to the food truck question, if you're going to have the food trucks there, will there be staff from the tavern outside making sure that you don't have patrons congregating out there?
Yes.
Or those that are, if I were to come up and I wasn't coming into the restaurant, would I still be able to go to the food truck? Or is it just for just for the tavern yet?
Sure. No, we've actually had both of these instances already occur at our Monrovia location where we have customers that are not patrons of ours, but they come to the food truck, and we encourage that because we like to partner with other small businesses and encourage them. So we don't prohibit that at all. And we've never had any issues with customers drinking outside of the actual location in our Monrovia spot. So it's small enough, and we have adequate staffing to ensure that no alcohol trespasses onto the public property where it doesn't belong.
Okay. And you said that the normal closing hours is 12 a.m.?
That's correct.
Have you read through all of the conditions of approval as proposed by staff?
I have. I've read through all 20 conditions.
And are you in agreement with those conditions of approval?
For the most part, I do have 2 comments or requests on 2 of the conditions, if I may. The first comment would be on the last condition, actually, which is the effective date of the CUP. We've been told that it's standard for a 5-year period for a tavern use in this city for the CUP, but we're requesting that that be extended to a longer period of time since we're not a true tavern use and we only serve beer and not hard alcohol or wine or any of the more potent alcohols. And because it is a financial burden to how smaller businesses, our current CUP in Monrovia is actually a lifetime CUP. And so we understand that this city is different, but we're requesting, if at all possible, that that could be extended longer than the 5-year period. And then the second comment is on the outdoor speaker prohibition. Let me see what number that one is.
Number 13.
Number 13, yes. And we're requesting, since we do have a patio, to be allowed to use outdoor speakers so long as they comply with the noise ordinance in Glendale, and they can be responsibly used at a low level at appropriate times.
And the outdoor patio is facing Brand Boulevard?
No, it's actually on the back side. It does face Cypress slightly, but mostly it faces towards the car dealership. It does have about a 7-foot-high or so cinder block wall that it encases it, so it's not visible.
All the way around?
All the way around, yes, sir.
You do have residential to the southeast. Were you planning on using that outdoor area during all hours of operation?
If we're allowed to do so, yes. However, if it doesn't comply with the noise ordinance, then we can limit the hours of use of that outdoor area.
And the neighboring tenant, do they have access to that outdoor area as well, or just your tenant space?
All of the tenants of that building have access to that patio. It will be licensed with the ABC for consumption, but it won't be exclusive to us only.
That'll make it hard to regulate and enforce who's using it.
I suppose.
Question for staff. When we were looking at that proposed outdoor area, did the police department have any concerns about that?
The police department didn't note concerns in their conditions about the patio.
Okay, and then I'll ask again just to make sure I didn't miss something. There was no comments from any residences in the area?
No
Emails,
comments.
phone calls, nothing relating to the project?
No comments were received.
Okay, thank you.
Thank you.
What I'm going to do, we'll go ahead and we'll modify condition number 13 to allow the speaker system outside in the patio area, but we're going to limit or establish a cutoff time of 10 p.m.
Okay.
Is that?
Yes, that's acceptable.
I think 10 p.m. is a reasonable time.
Yes.
And then hopefully the neighbors upstairs will be able to get some sleep after that. And hopefully it will be kept to a minimum based off of compliance with the noise ordinance.
Absolutely.
And then secondly, as it relates to condition number 20, I think we're going to keep it as is,
Okay.
only because similar to the previous cases, the first time we've had this, we'll have two taverns next to each other. I think 5 years is appropriate to be able to verify that there won't be any impacts. And if there are no impacts at that time, then you definitely come back and ask for more. Is that
That's acceptable. Thank you.
okay? So, thank you very much.
Thank you.
Again, no other speakers or anyone in the audience wanting to speak on this case? I'm going to go ahead and close the public hearing. Based on the findings recommended by staff, facts and information presented at the hearing, and the other applicable departments' input, I am going to approve the subject conditional use permit with the two modifications, as I just noted, to our conditions of approval, as mentioned by staff. So, conditional use permit case number 1622327 will be approved with conditions modified. After the hearing, the decision will be prepared in writing, will be in the form of a letter sent to the applicant and to all persons who responded to the public notice, either by speaking at this hearing or by submitting written responses and provided their name and mailing address. The date of the decision will be the date appearing on the letter. As it relates to appeals, under the appeal provisions, Title 30, Chapter 30.62 of the Glendale Municipal Code, the decision may be appealed to the Planning Commission within 15 days of the date of the decision. Anyone wishing to appeal may obtain forms and brochures, procedures from the Building and Safety section, the Permit Center office, located on the same floor. We have no other cases scheduled for today. I am going to officially close the hearing. I want to thank everybody for coming out. It is 10:22. Thank you very much.